seat and we'll get started here. Our next topic is one that should be valuable for everyone, because I don't think anyone here can raise their hand if they haven't had a difficult client. I seem to have a lot of them, so I'm looking forward to Lori Gooch's perspective on dealing with these difficult personalities. Lori works at the Harris County Public Defender's Office as an assistant in the Mental Health Division, so she's dealt with some uniquely difficult clients when you add on maybe difficult personalities with some form of mental illness. I asked Lori if she had any special requests for introduction, and she said, nope, short and sweet, without ado, Lori Gooch.
Good afternoon. Again, my name is Lori Gooch, and I'm here to speak to you about dealing with difficult clients. It's something that we all have dealt with, no matter where you are in the legal field. If you've been in it many years or you just started, you will run across a difficult client. And I've run across several of them dealing with in mental health issues. What I wanted to first start out talking about is, when you come across these special situations, as I have in the mental health division, you want to know, what is your duty? Sometimes you come across these situations and people are so difficult, what is it that I'm supposed to do for them? And the Texas Disciplinary Rules of Professional Conduct says that Rule 201, that you're an advisor. In advising or otherwise representing a client or a lawyer, shall exercise independent professional judgment and render candid advice, provide straightforward, understandable advice, and advise on what you know and seek referrals for what you do not know, and provide advice when asked in some cases, and when not asked, when the client proposes a course of action that is likely to result in a substantial adverse legal consequences to the client. When I was reading that, it was kind of funny, because half the time in what we do in criminal law, the client proposes an action, a course of action that is likely that it's going to result in adverse legal consequences. And how do you deal with that? And how do you effectively give advice when that situation arises? An example of that, I remember when I was working for doing mostly indigent defense before I came as a public defender, and I had a client that wanted me to he was a true habitual, and he wanted me to approach the judge about a bond reduction on the first day. And this was back when the DA's office wasn't always what is the word I'm trying to say, as good as filing those motions to hold a no bond. And I advised him that I would not do that, and why I felt that he should not do that. And he ended up listening to me, and the state did not file the motion to hold a no bond within the 10 days, and he was able to get a bond and bond out. So when we're talking about our duty, we know that we're supposed to give them candid advice, but what kind of representation do you want to give to this particular client? Now, there's two schools of thought of two types of representation. One is lawyer-centered representation. This is probably how I practiced law all the way until I got to the public defender's office. It's very lawyer-focused. The lawyer is defending the case, not the client. It's more law-centered, and the client is not to be helped but to be managed. I knew the four corners of my case. I knew everything about it, and I wasn't too concerned what my client had going on after the case, or how the case, what they had in the household going on, or what brought them to getting to this certain case. All I was worried about is this case, whether or not I can get a not guilty, a good plea, or a dismissal on it. The other school of thought is client-centered representation. It's client-focused, and this is more what we do here at the Public Defender's Office. It handles not only the client's legal issues, but looks to assist them in the cause of entry into the criminal justice system. And it takes the approach of getting to know your whole client, not just the facts surrounding the case. So you understand what's the state of mind that they were in, what was going on with them beforehand. Excuse me. It gets you more delve into their lives, and for me, it made something that made me uncomfortable when I was in private practice, because it wasn't what I was focused on doing. I was focused on the facts and focused on what I could do to help them in this case and managing them through that. And I think what really is the best thing is a little bit of both. You want a lawyer-centered and also a client-centered kind of representation, because you have to get towards your goal, which is a good lawyer-client relationship. And that's a very human relationship built on a foundation of loyalty by the lawyer and trust by the client. And the sole mission of the case is to help the client reach an outcome that he desires, which is very difficult in criminal law cases because, as you know, our clients want the case dismissed and want it to go away. And sometimes that is not, most of the time, that is not going to happen, and they're going to be mad at you, especially if you're doing like we are, indigent defense. You're not getting paid by them, you are getting paid by the courts. So you are going to run into mindsets that hinder your representation. Like they tell you you're part of the system, you work for the state, you work for the DA. They feel that you do not care about them no matter how much you go about doing what you want, listening to them or doing what they want you to do. They believe that you are incompetent and you couldn't find any other job, which is why you're a public defender. They believe that we believe that they are guilty, and they think that we will fight harder for them if they can prove to us their innocence. And they believe that you get for what you pay for. If you haven't paid any money, then how really is this person really going to fight for me? So let's talk about the client when they get arrested. And I can tell you that since we started doing the bail hearings, I've seen this a lot. When a client is arrested, it's for the client, it feels like a moment of the greatest need and desperation in hours and days after arrest. And I can't tell you that even if it's a true habitual, a person who has a rap sheet as long as their arm and they're caught up on a misdemeanor, when we're on our bail hearings and you're talking to them and interviewing, they are upset and they feel like it's the end of the world because they're back behind bars again, no matter how small or great the charge is. And it's also a time when they're most likely to ask for help or seek change or seek response. But the problem is when we see them in the bail hearings and we're able to give information, but the time they get to you, they've had time to simmer and get upset and get angrier. And this looks like an arrogant, prideful, or rude person who routinely listens to jailhouse attorneys because by the time they get to their first appearance and you are appointed, they have had time to talk it over to anybody who would listen. They refuse to listen to advice, and they have unreal expectations about the judicial system, like getting time served on a second BMV. So how do you deal with these kind of people when they are ready to be helped? Now they sit in jail and now they're angry and upset of how they have gotten themselves into this situation. Well, we deal with them by engaging more in our client-centered lawyering. And you'll notice the first thing I have up there is patience. Patience, 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 and more patience. And the second thing is listening, because even if I've seen from working in the bail hearings, these people have a story to tell. They want to tell you what is going on, and even though we come in with our mindset, especially if you were like me, lawyer-centered, you got the facts, you read the offense report, you come in and you're looking, I only need to know these 5 things from you. I don't need to know that you were at your grandmother's house 2 nights before this happened, because that is not pertinent to this night. You want to listen as much as you can and then start educating and explaining to them the system and how it works and advising them. And most times they won't listen, but you will have to use that when your patience comes in, where you have to reiterate again and say it one more time before they finally get it. You have to try to maintain control. Sometimes that means walking away. And by no means do I mean that because you have a difficult client that you should sit there and be berated and cursed out. Nobody deserves that. Sometimes your clients will be angry and they will use colorful language, but they shouldn't be abusing you. So maintain control and walk away from those situations when you can. You can speak to them on their terms, and also understand, let them know that you will be fighting for them. So you've done all this and your person is still difficult. You've been through a couple of resets, you've listened, you've exercised patience, you've tried to educate, you tried to advise. Then you need to wonder, is this person difficult or are they sick? You have to understand and recognizing mental illness in people. Here are some common qualities that people have who have mental illness. They have trouble thinking clearly, have suspiciousness and uneasiness with others, poor self-care or poor personal hygiene, increased sensitivity to sounds or sights, mistaking noises for voices, unusual or overly intense ideas, strange feelings or having no feelings at all, poor time concept and avoiding eye contact. Now, you've gone through this and you've seen that this person, you've gone through a couple of resets, then you need to ask yourself, is this person competent? Now, the Code of Criminal Procedure tells us that a defendant is presumed competent to stand trial and shall be found competent to stand trial unless proved incompetent by preponderance of the evidence, and that a person is incompetent to stand trial if the person does not have the sufficient present ability to consult with the person's lawyer with a reasonable degree of rational understanding or a rational as well as a factual understanding of the proceedings against them. So what that means is if you've been through a couple of resets and you've never been able to talk about the offense because they've gone down every rabbit hole, then maybe we need to start looking at, is this person really competent enough? They're just not angry and being rude and being difficult. They could have a mental health issue. If they are, understand that it's not their fault. Mental illness or defect makes your client as well as the complaining complaining witness a victim in the case, and you have to be extra patient. You can reset their case to stabilize, to see if they can get on medication or detox if that is the situation that is causing their behavior. If still not stable, then you file a motion for a competency exam, which will usually take you about 30 days, sometimes 45 days here in Harris County. If they come back competent and they're still difficult, just try to do the best you can. Sometimes it helps in our organization, we're able to switch off. Sometimes some people are just not willing to hear something from a person who looks like me, where they would much rather hear it from my colleague who's a white male and they can understand it better from them. You have to deal with certain different personality groups. So understand that. I'm almost getting close to the end, so I want to go over with you some things that I got from Mark Bennett on his truisms of dealing with, he says crazy people, but I put difficult people, but you'll see crazy in there. If you do not have to deal with a difficult person, then don't do it. There are some people who just were going to be difficult no matter what you do. I know some people who just like that, and if you can avoid it, avoid it. You can't outsmart crazy, and you can't fix crazy. You could out-crazy it, but that makes you crazy too. When you get into a contest of wills with crazy, you've already lost. So you don't try to get into a contest of wills with people who are crazy. And a crazy person doesn't have as much to lose as you do. So really, try to keep these things in mind, that whatever your desired outcome is to get away from the crazy person. Your desired outcome is to get away from the crazy person. And you have no idea what the crazy person's outcome is. So you don't know what you're up against. A crazy person sees anything you've done as justification for what they're about to do, and anything nice you do for a crazy person, they will use that as ammunition against you later. I remember I had a case that I had worked on, a misdemeanor case. The guy had substantial mental health history, and we ended up getting it dismissed. And after we got it dismissed, he told me, "Don't worry, Ms. Gooch, one day you'll make a fine lawyer." So Sometimes you just can't win no matter what you do. The crazy person sees any outcome as vindication. And when you start caring what the crazy person thinks, you're going to join them in their craziness, and you don't want to do that. So that brings me to the end of my presentation. Do you all have any questions for me? Yes.
Is there anything the Harris County Jail can do to stabilize somebody who's being confident? I mean, I have a lot of clients that, I mean, they're confident, but they're doing some sort of, I don't know what, but, you know, they still seem off to me, but they're being confident.
Well, the jail has, you can't force a person who is on who takes medication, who has a mental health issue to take medication. They can come in and they have an absolute right to refuse it. The only times that you can do a forced order for medications if that person is a danger to themselves or to others. So they have to wait till they deteriorate, then they have to go and get a court order to give them medication. So during that time period where they are a danger to themselves or others. And so that's the only time when the jail has at its disposal forced medication upon a person who has a mental health issue.
But I guess I didn't mean it in a forced sense. I mean, are there resources in the jail where if somebody does have a mental health issue, they can see?
Yeah, they can send out, I forget what they call the forms to go to see the doctor. It usually takes about a week or so for them to do so, but it's up to that person that once the doctor gives the recommendation, or if they even give a recommendation for meds, whether or not they'll take it and go forward. Any other questions? Well, thank you.
All right. We got a little time before Jordan Lewis. You know, one time I was grieved because I didn't get a case no billed by a grand jury fast enough.